Welcome to our third lecture entitled Searches, Summons, Arrests and Rights or Safeguards for an Accused Person. This video is part 2 of a 4-part series. We hope that the time spent paying attention will be beneficial to you. This lecture has 3 major divisions. First, summons in general. Second, criminal summons. Third, public summons. Apparently, almost anyone can be summoned. In 2013, a judge of the High Court of the FCT U, Musale, ordered the then President Goodluck Jonathan to appear before it as a witness in a forgery trial involving 3 journalists. This raises the question, was that a legitimate exercise of judicial authority? Stay tuned to find out. 2019 will go down in history as the year that a sitting Chief Justice of the Supreme Court of Nigeria was forced out of office through the instrumentality of the Code of Conduct Tribunal. January 14, 2019 was the date that his trial commenced at the Code of Conduct Tribunal. However, the then Chief Justice was absent. The reason adduced for his absence at the commencement of his trial was procedural errors surrounding the summons. Let's elaborate on that reason with the help of the publication of OTV, dated January 14, 2019, and entitled CJN Onnoghen Defense Absence from CCT, False Appearance Notice. According to that publication, the lead counsel to the then CJN, Mr. Aliyu Umar San, admitted that the then CJN was not properly served with summons according to the law. The lawyer for the prosecution countered that the law only requires the defendant to be aware of the pending charges and that it was the then CJN's choice to ask his aide to receive charges and summons on his behalf. In the end, the lawyer for the prosecution conceded that the service of the charges and the summons ought to have been personally saved on the then CJN. In his words, by what the registrar has said, although the defendant was the one who directed his personal assistants to accept service on his behalf, and what the law says is that he must be personally saved, the processes should be served personally on him. If after the service is done and the defendant is not present, we can then argue whether or not he needs to be present on the grounds that he has filed a motion challenging the jurisdiction of the court. This news story raises some questions. What is meant by the expression properly served with summons? Is it mandatory that the summons must be personally received by the person therein named? Can summons be said to be improperly served if the person named therein nominates another to receive the summons on his behalf? To properly situate or put into context the issue of the power of summons or the power to summon, let's discuss a few news items that involve Nigerian courts exercising their power to authorize the issue and execution of both criminal and public summons. Our first source is a Punch newspaper article written by Ade Adesomaj entitled "Of a Robbery Court Summons Saraki Over Fresh Criminal Complaints," published September 18, 2018. A Grade 1 area court in Akpo Estate, Lugbe, Abuja, has ordered the former Inspector General of Police, Mr. Ibrahim Idris, to serve a summons on the Senate President, Dr. Bukola Saraki, to compel him to face the criminal complaint initiated against him by a private lawyer in respect of the bloody bank robbery in which many died in Offa, Kwara State, earlier this year. The criminal complaint was initiated by an Abuja-based lawyer and rights activist, Oluwatosin Ojamo, whose lawyer told the court on Monday that the former IGP had given assurance that the necessary court papers would be saved on the Senate President. The police had said their investigations linked Saraki to the kingpin of the robbery operation. The Senate President is the sole defendant in the criminal complaint initiated by the private lawyer. The criminal complaint, marked CR 196/2018, was said to have been initiated by Ojamo under Section 89, subsection 5 of the Administration of Criminal Justice Act 2015. It sought Saraki to be summoned for allegedly ignoring police invitation to answer to an allegation involving the investigation of the suspects of the Offa robbery. The complaint stated that Saraki's alleged refusal to honor the invitation amounted to obstructing a criminal investigation and disobeying a public officer carrying out a lawful responsibility. This alleged conduct, it said, was an offense punishable under Section 136 and 149 of the Penal Code Law. The judge handling the case at the Grade 1 Area Court, Akpo Estate, Lugbe, Federal Capital Territory, Abuja, Abdullahi Ganibe Ogbede, had on September 10 this year ordered the issuance of a summons on former IGP following Saraki's absence from court. On Monday, the complainant's lawyer, Mr. E.S. Marcus, said he was informed by a Deputy Superintendent of Police in the legal units of the Nigerian Police Force headquarters in Abuja, identified as Mahmood, that the former IGP had directed the legal unit to ensure the prompt service of the court papers on Saraki before the next hearing date of October 3, 2018. He said the defendant is not in court. At the last date, the court issued a witness summons on the former IGP to come and show cause why the police failed to effect service of the criminal summons, warrant of arrest, and other processes on the defendant. The witness summons was served on the Nigerian Police Force by the court's registry. However, we received a call from DSP Mahmood of the legal department of the Nigerian Police Force headquarters that the matter has been assigned by the former IGP to a particular unit of the Nigerian Police Force to effect the service of the summons on the defendant and arrest him. Marcus explained in court on Monday that his client, who was supposed to bear the responsibility of saving Saraki with the complaint, had to resort to seeking the IGP's involvement in accordance with Section 122 of the ACJA when it became difficult for him to serve the Senate President. According to the lawyer, the former Inspector General of Police is required under the law to either produce the defendant in court or attend court to explain why the defendant was absent. He then applied to the court to grant a short adjournment to enable the police to save the processes on Saraki. The judge, Onnoghen, granted Marcus' request and adjourned the case till October 3. The criminal complaint against the Senate President read, criminal complaint brought pursuant to Section 89, subsection 5 of the Administration of Criminal Justice Act, ACJA 2015. Please cause a summons for a direct criminal complaint on the defendant on the following terms: that you, Dr. Bukola Saraki, on or about the 24th day of July 2018, within the jurisdiction of this honorable court, did refuse to honor the invitation of the Inspector General of the Nigerian Police Force to report at the police headquarters in FCT Abuja to answer to an allegation involving the investigation of some criminal suspects involved in a case which the Nigerian Police Force is currently investigating, thereby obstructing a criminal investigation and disobeying a public officer carrying out a lawful responsibility. You thereby committed an offense punishable under Section 136 and 149 Penal Code Law, whereas the complainant is praying the court to charge the defendant accordingly. The key points to ponder from this story include: who can order the service of a summons on someone? What is a criminal complaint? Who can make a criminal complaint and to whom? Who can serve court papers on an accused? Who can order the issuance of a summons on an accused? What is a witness summons? And how is it different from a criminal summons? What is a warrant of arrest and when is it used? Can you draft a charge based on the complaints in the story? Our second source is a Premium Times article written by the News Agency of Nigeria entitled Court Orders Substituted Service of Fraud Charge on Onnoghen, published April 18, 2018. The Federal High Court of Abuja has granted an order seeking to serve criminal summons by posting them at the residence of Victor Onnoghen in Asoko, Abuja. Justice John Soho gave the order on Wednesday following an application made to that effect by counsel to the federal government, Aminu Alihu. When the matter was called, Mr. Alihu told the court that all attempts made to effect service personally on Onnoghen had proved abortive. The matter was last adjourned for service, and for the second time, the defendant evaded service as did the previous ones. One of the bailiffs of this court went to the address of the defendant and was almost shot by the police guarding his house. The prosecution told the court that Mr. Onnoghen was aware of the matter and that his counsel had earlier said that he had traveled out of the country and would appear in court as soon as he returned. The federal government had filed a 4-count charge bordering on forgery, impersonation, and fraud against Mr. Onnoghen, a self-acclaimed United Kingdom-based private investigator. The federal government alleged that an investigation carried out by the police following a petition revealed that Mr. Onnoghen tried to obtain money from Andy Oban through fraudulent means. Justice Soho wondered why someone who the state wanted to bring to justice will be protected by agents of the same institution. Accordingly, leave is granted to serve the criminal summons through substituted means. The judge urged those who will be going to effect the substituted service to be careful following what had transpired the first time they tried to save the defendants. He adjourned the matter until May 21 for arraignment. Following is a rundown of key points to ponder from this story. What is a criminal summons? On what basis was it issued by Justice John Soho? If personal service on the accused is impossible, how otherwise might service be effected? Are there any consequences for an accused who evades personal service? What is the correlation between the grant of leave and the service of a criminal summons through substituted means? Our first source is a Sahara Reporter's article entitled Speakership Court Orders Substituted Service on Baja Biamila over U.S. Fraud, published June 4, 2019. Justice Nkanu of the Federal High Court has ordered that Femi Bajabiamila, a federal lawmaker, be saved through substituted means. The proceedings of the suit seeking to remove him from the House of Representatives over his alleged conviction in the U.S. for fraud-related offenses. Justice Ekwo said that since the court was unable to serve the processes on Baja Biamila in person, the lawyer to the plaintiff, Olasupo Aziz, should do so by substituted means. Cases of this nature are of public interest, and it is either you are ready or not, the judge said. As a result, Justice Ekwo adjourned the matter until Friday, June 7 for further mention. The originating summons filed by Philip Ondi through an originating summons by his lawyer, Barrister Ayodele Justice, submitted that Bajabiamila was not a fit and proper person to be elected as a federal lawmaker or speaker, having been allegedly convicted of a $25,000 fraud by the Supreme Court of the state of Georgia, USA. Ondi is contending that under Section 66, subsection 1 and C and D of the 1999 Constitution and the verdicts of the Supreme Court of Georgia, the mood of our nation today will not warrant placing the position of the Speaker of the House of Representatives in the hands of any individual that has a taint of questionable character. In the affidavit attached to the suit, Ondi averred that Bajabiamila, who was then known as Femi Baja, accepted payment of $25,000 client's money as personal injury claims and deposited those funds in his attorney trust account in January 2003, which he failed to disburse to the client. He further stated that Bajabiamila violated Rule 1 to 15, subsection L of Georgia Rule of Professional Conduct in Bar Rule 4 to 102, subsection D, which is punishable with disbarment and was suspended from law practice in the USA for 36 months, 3 years, even though he refunded the client's money in 2006, and his lawyer filed a certification of compliance of the Supreme Court ruling as of March 2007. Meanwhile, a member of the House of Representatives, Raphael Nana, has brought an application to be joined in the suit seeking to stop Bajabiamila. Justice Ekwo directed the counsel to Nnana C. Onyemachi to save the application for joinder on the parties in court. Why did Justice Inyame order that the federal lawmaker be saved through substituted means? The fourth service is from the cable in an article entitled High Court Reverses Summons on Bajamia Miller, published June 7, 2019. Femi Bajamia will no longer have to appear before an area court in Karachi, Abuja on Monday. A high court sitting in the Federal Capital Territory, FCT, on Friday quashed the summons by the area court asking the aspirant to the speakership of the House of Representatives to appear before it on June 10, 2019, a day to the election of leaders by the National Assembly. The court also ordered the area court to stay action in whatsoever manner on any matter relating to Bajamia. Anas Issa Mohammed, the area court judge, was further ordered by the High Court to transmit certified record of proceedings before it within 1 week. Othman Musa, a judge of the FCT High Court, gave the order following an ex parte motion filed by Bajamia. He had the African People's Party (APP) and the area court judge seeking two reliefs. The relief are an order of this honorable court granting leave to the applicant to apply for judicial review for an order of certiorari to remove into this honorable court for the purpose of its being quashed the proceedings, decisions, criminal charge, and order of His Worship Honorable Anas Issa Mohammed of Grade 1 Area Court, Karachi, Federal Capital Territory, Abuja, made on 30th May 2019 in charge number CR 349-2019 and motion number M19-2019 between African People's Party (APP) versus Honorable Femi Bajamia, aka Femi Baja. An order of this honorable court staying all proceedings and hearing of the criminal charges, actions, and decisions of His Worship Honorable Anas Issa Mohammed of the Grade 1 Area Court, Karachi, Federal Capital Territory, Abuja, made on the 30th day of May 2019 in charge number CR 349-2019 and motion number M19-2019 between African People's Party (APP) versus Honorable Femi Bajamia, aka Femi Baja, which affects the subject matter of this application, pending the hearing and determination of the motion on notice for an order of certiorari filed by the applicant hearing. In his ruling, Justice Othman Musa granted the ex parte prayers of the applicants. He said, where at any stage of proceeding before final judgment, in any cause or matter in an area court, a person alleges that he is not subject to the jurisdiction of area court, the proceedings shall, on the application of that person to the High Court, be transferred to the High Court, which shall inquire into and determine the truth of the person's allegation. It is for the reasons advanced above that I proceed to grant the application as follows. Leave is hereby granted to the applicant to apply for judicial review for the issuance of an order of certiorari to remove the whole proceedings, orders, pending applications, and the entire record of honorable Anas Issa Mohammed in Grade 1 Area Court of the FCT, Holden in Karachi, in charge number CR 349/2019 and motion number M19/2019 between African People's Party APP versus Honorable Femi Bajabiamila, aka Femi Baja, into this court for the purpose of being quashed by way of judicial review. Is further ordered by virtue of Section 12, subsection 1 of the Federal Capital Territory Area Court Act and Order 44, Rule 3, subsection 6 and 9, that the leave so granted shall operate as a stay of further action or proceedings by the respondents, particularly the proceeding in Grade 1 Area Courts. Honorable A.I. Mohammed, the two respondents in this application in CR 349/2019, is hereby stayed. It is ordered that the second respondent, the area court judge, either by himself or the registrar of the lower area court, is to transmit a certified record of proceedings of the lower court into this court or make same available to the applicant upon payment of the required fee within 7 days from the service of this order. The case was adjourned till June 20, 2019 for hearing of the motion. That article raises the following issues. Can an accused challenge a summons? Why did the Federal Capital Territory High Court quash the summons of the area courts? Our fifth and final source is a Vanguard newspaper article entitled Alleged 200 million naira dot check. Court orders public summons against Senator Uzodinma, published September 25, 2018. Ekuwa Grade 1 Area Court of Abuja on Tuesday ordered a public summons to be published against Senator Hope Uzodinma, accused of issuing 200 million naira dot check. Uzodinma, a serving senator representing Imo West, SMIEC Engineering and Chemical Construction Company, Niger Global Engineering and Technical Company, were charged with alleged issuance of 200 million naira dot check. The judge, Mr. Abdul Wahab Mohammed, made the order following a motion filed by the plaintiff's counsel, Mr. Oluwatosin Ojamu, asking that a public summons be made against the defendants. Ojamu, counsel to Chitex Ventures, and Chima Akuzi, the complainant, had brought the motion pursuant to the provision of Section 41 and 42 of the Administration of Criminal Justice Act, ACJA. He averred that the motion had become imperative as the defendants appeared to be absconding from justice after they were served a warrant of arrest on September 18. He told the court that the joint warrant of arrest issued against the defendants was duly served on the Inspector General of Police for the execution of their arrest. Ojamo, who tendered an acknowledgement copy of the letter from the police, said the defendants had continued to feign knowledge of the existence of the suit. Meanwhile, Ojamo had drawn the attention of the court to an interim order granted by Maitama High Court to stay the proceedings of the criminal complaints against the defendants. He said the validity of the order had, however, lapsed on September 24, adding that the defendants had no justifiable reason to stay away from the court. Ojamo said the defendants had also filed a judicial review in the Maitama High Court against the complainants, the trial judge, and himself, showing their knowledge of the suit brought against them. The News Agency of Nigeria recalls that a warrant of arrest was issued against Uzodinma and a not guilty plea was entered for the other defendants in accordance with Section 478 ACJA on September 18. NAN also recalls that Cheaters Ventures Limited and Chima Akuzie had made a direct criminal complaint against the defendants over alleged issuance of a UBA 200 million naira dot check. The judge adjourned the case until October 29. The key poses from this news story are as follows. What is a public summons? How does a court authorize its publishing? What must the other side do before a court can issue a public summons? Why was the joint warrant of arrest issued against defendants, save on the Inspector General of Police? Why would a party to the suit seek a stay of execution? Why would a party to the suit seek a judicial review? When is a warrant of arrest issued? What is a direct criminal complaint?
With these news articles and the highlighted points to ponder, key points, questions, and posters at the back of our minds, let's now delve thoroughly into the second part of the lecture series, Searches, Summons, Arrests, and Rights or Safeguards for an Accused Person. The second part of Searches, Summons, Arrests, and Rights or Safeguards for an Accused Person will deal with the power of summons or the power to summon. Let's now consider two definitions of the word summons. The online source uslegal.com defines it this way. A summons is a paper issued by a court informing a person that a complaint has been filed against her. It may be served by a sheriff or other authorized person for service of processes called a process server. The Oxford Dictionary of Law, 5th edition, defines it as a court order to an individual to appear in court at a specified time and place. Simply put, a written, not oral invitation to appear before the court to respond to a charge or charges against him. Either a summons or a warrant of arrest can be used to secure the attendance of an accused at his trial. There are two types of summons under Nigerian criminal law. Criminal summons, an order in writing commanding a person to whom it is addressed to appear in court on a named date and time to answer allegations of crime made against him or her. That's criminal summons. For public summons, simply the publication of a warrant of arrest. It is employed where a warrant of arrest cannot be executed due to the wanted person evading arrest. Please note that the difference between the two is a potential exam question. Also note that the expression public summons is missing from the ACJL and the CPA, but is present in the ACJA and the CPC. As has always been our practice, we will address this topic using 4 subtopics: ACJA, ACJL, CPA, and CPC. Under Section 122 of the ACJA, persons authorized by statute to serve summons include 1. A police officer, 2. An officer of the court issuing it, 3. Any other public officer, and 4. A courier service company duly registered with the Chief Judge as a process service agent of the court under this Act. Please note that the last point is an innovation of the ACJA. Under Section 86 of the ACJL, we have 1. A police officer, 2. An officer of the court issuing it, and 3. Any other public servant. Under the CPA at Section 88, we have the exact same thing as the ACJL. 1. A police officer, 2. An officer of the court issuing it, and 3. Any other public servant. Under the CPC, we have the following: 1. Section 48 of the CPC, by the way, a police officer, 2. An officer of the court issuing it, 3. Any other public servant who, under any law, for the time being in force, may be authorized to serve summons. Time of service of a summons. According to the ACJA in Section 116, it states that it may be served on any day, Sunday, and public holiday inclusive. Under the ACJL, it states that, as a general rule, it may be served on any day between Monday and Saturday, and that such service should be effective between 8 a.m. and 6 p.m. Please see Section 81A of the ACJL. But Section 81B of the ACJL elaborates that it is permissible to serve a summons on a Sunday or public holiday, and that service on those days doesn't invalidate the summons. However, such a summons shall take effect from the next working day. The position under the CPA is the same as the ACJA in Section 82. The CPC is silent, and so by implication those provisions do not apply within this jurisdiction. Time of issuance of a summons. Section 116 of the ACJA states that it may be issued on any day, Sunday, and public holiday inclusive. Section 81A of the ACJL states that, as a general rule, it may be issued on any day between Monday and Saturday, and that such issuance should be effected between 8 a.m. and 6 p.m. Section 81B of the ACJL is subject to misinterpretation, and here is why. It is very clear that a summons served on a Sunday or a public holiday takes effect from the next working day. But as respects a summons issued on a Sunday or a public holiday, what is its effective day of issue? The law is silent. What was the intent of the drafters of the ACJL? Section 82 of the CPA is on all fours with the ACJA. The CPC is silent, And so those provisions are alien to this jurisdiction. Section 131 of the ACJ says that if it can be proven that the suspect has been served with a summons, but the suspect declines to honor the invitation on the specified day and place, and his absence is not in compliance with Section 135 of the ACJA, then the court has the discretion to issue a warrant for his arrest and production before the court. Now, why do we say that the court has a discretion? Because the Act uses the word may issue a warrant for his arrest and production before the court. Section 94 of the ACJL uses the word defendant instead of suspect, and so that place would read, if it can be proven that the suspect has been served with a summons, if it can be proven that the defendant has been served with a summons, but the defendant declines to honor the invitation on the specified day and place, then the court should issue a warrant for his arrest and production before the court. So note that unlike the ACJA, which uses the expression may, meaning the court has a discretion, the ACJL uses the word shall. So the court has no discretion. Also note that under the ACJL, there is no provision for dispensing for absence of the defendant. Section 96 of the CPA replaces the word suspect with accused. So it would read, if it can be proven that the accused has been served with a summons, but the accused declines to honor the invitation on the specified day and place, and his absence is not in compliance with Section 100 of the CPA, then the court has the discretion to issue a warrant for his arrest and production before the court. Please note that the CPA, just like the ACJA, the Act uses the word may, so the court has discretion. Also note that just like the ACJA, but unlike the ACJL, that there is a provision for dispensing with the attendance of the accused in Section 100 of the CPA. Section 70, subsection 1b of the CPC uses the expression a court or a justice of the peace. It clarifies that a summons or a warrant of arrest may be used interchangeably or alternatively or in parallel. It permits for the absence of the person invited. It uses the expression any person. It mandates the court to note down in writing its reasons for issuing a summons. It empowers the court to issue a warrant of arrest in addition to or as an alternative to the summons only after noting down reasons in writing. It raises the issue of due service on time. It says that if it can be proven that any person has been served with a summons timeously, but such a person declines to honor the invitation on the time specified, and he has no reasonable excuse to offer for his absence, then the court may issue a warrant for his arrest in addition to a summons, or issue a warrant for his arrest instead of the summons.